Hello and welcome to this edition of the Topical Discussion as we dissect yesterday's ruling that annulled the election of Honorable Nalukoola-Nambi, ending his 2 months stint in Parliament. He was sworn in on 26th of March, and yesterday court agreed with the petitioner Nambi Farida, who argued that more than 16,000 voters were disenfranchised. She also argued that Nalukoola engaged in campaigns on the final day of the ballots. Well, plus several other grounds. The lawyers for Nalukoola have since issued a notice of appeal. What does this mean? And what are the implications? What are the key takeaways from yesterday's ruling? I'm joined by Counsel George Musisi, lawyer for the National Unity Platform, who represented Nalukoola in the petition. Good to have you, and a very good morning.
Pleasure to be here. Good morning, Simon, and good morning to the viewers.
How resounding is this loss to you?
Well, it is a bitter one, given that what surrounded the process of voting, the process of the campaigns in Kawempe North. When we met the Electoral Commission chair, when we were trying to have Honorable Nalukoola gazetted, we had a meeting with the Electoral Commission and a number of his officials, together with Honorable Nalukoola and the Secretary General. The chairperson said in his own words that I've never seen irregularities like which led even to a 14% turn-up. That had never happened in a by-election in Kampala. It was unprecedented. And of course, this case was also unprecedented in many ways. One, it is one where the victim of the irregularities was now on the defensive. Because as it happened, the winner actually was on the receiving end of almost all the injustice. Out of the 10 candidates, he was the only one, right from nomination day, if you remember how he was brutalized, his rallies were stopped throughout the campaigning period. However, and our argument in court was that despite all that, actually he had to skirt through a win. He was the victim, possibly would have been the one to go to court. Yeah, but the irony here is that during cross-examination, during the hearing, at one moment, the defendant, the respondent in this case, was questioned whether he was satisfied with the way the Electoral Commission handled the election. And he said, yes, I am happy. Yes, because one, most of the things were outside the control of the Electoral Commission. What transpired was actually most of them were outside the control of the Electoral Commission, and those are some of the problems we have with the judgment. That the Electoral Commission, at some point, an RDC was barring a commissioner of the Electoral Commission, Mr. Simba, from accessing the polling station, an RDC. So an RDC was not an official of the Electoral Commission. So the Electoral Commission actually did its best in delivering what could be done, because there was no failure on the part of the EC, save for saying, maybe they would have said that we should stop the election.
Hours to the judgment, you said, and I want to quote, High Court shall deliver its judgment in the frivolous Kawempe North petition today. Frivolous.
Yes, frivolous, that a petition which is brought without merit. Like I've said, Honorable Nalukoola should have been the one to go to court. The agents, the security agents who beat up people, who tried to stop people from campaigning, were actually coming from and with the protection of agents of the petitioner, the NRM candidate. The impugned 14 polling stations where people came and disrupted the tallying and the counting of the votes, they were some of the most protected security-wise polling stations. One of them even had 2 members packed. So it's also ironical that on these polling stations where there was a heavy security, heavy visible security, uniformed security, and 2 members, that's where uniformed goons in civilian wear, there were even 2 ministers on that scene, would come and disrupt voting, and none of them could be arrested. So you could see that I don't want to distinguish this judgment from what has been happening in the process of leading up to Kawempe North.
Do you concede or do you respect the judgment?
We strongly disagree with the judgment, but we respect it. Because as lawyers, we respect it. It's a court decision. We respect it. We disagree with it fundamentally, and that's the reasons why we've chosen to take the path of exercising our right to appeal.
The general perception out there is that you lost a case. Did you register any wins in court?
Of course, the key takeaway is that some of these issues have been documented. You know, every time you document something for not only public record but posterity, that is the only takeaway we can have. The biggest disappointment is that court didn't do a good job in analyzing the evidence adduced before it. It seemed to analyze only the evidence as brought by the petitioner. That is our biggest disagreement, and that's why the respondent instructed.
Oh, you were not convincing enough. Take, for instance, in explaining to the judge about the tally centers and who disrupted the tallying.
Well, of course, when it comes to analyzing and analyzing who of the 2 people is telling the truth, that is a discretion of the presiding judicial officer under the law. And of course, court sometimes is prone to error. That is why there are appellate decisions, some of which are overturned. But if you look at some of the issues that the petitioner brought, she alleged that there was bribery, both on the part of Honorable Nalukoola and by officials affiliated to him. That was thrown out by court. The issues of campaigning and on polling day and obstruction of voters. She had alleged that some officials from the National Unity Platform had obstructed voters and even election officials from accessing polling stations. That too was thrown out. Then, on the issue of campaigning personally by Honorable Nalukoola, which was an illegal practice that court found that Honorable Nalukoola at some polling station said Amanyi Gabantu Temugalia Mulukwe, and that tantamounted to campaign. And court says that, you know, the evidence of, I think a lady called Namanya Saliva was not challenged, which is, in our opinion, is wrong. Because indeed, she was cross-examined and she was challenged on those statements. So in the final analysis, court says they were not challenged, which is actually not accurate. But then again, whereas we are all interested in fast trials, this is also a peculiar case that, and we upload how fast, and I'm trying to be cynical here, court worked that hearing stopped on Wednesday last week, and 2 days later, we had the judgment after listening to reading over 10,000 pages of authorities and submissions. So it's also, I think, in the history of election petitions, one of the quickest election petitions to be heard and decided.
Yeah. If the judge annulled Nalukoola's election and ordered for a fresh election, why wouldn't you go for this election and instead choose to go to the Court of Appeal?
Because there are some erroneous issues that we feel should not be left on the court judgment. You know, if you don't challenge a court decision, it remains binding precedent. And given that we're in an election season, this can be used by other courts to handle similar petitions. Because, Simon, one of the most ironical and perhaps dangerous issues that when people are talking about disenfranchisement, which was one of the key grounds that court used to annul the election, was that the 14 polling stations had a total of 16,640 voters. And on all those polling stations, people voted. Voting was concluded within the timelines. However, what didn't happen was that the tallying was disrupted.
And you agree on that?
Yes, we agree on that. And court was faulting the Electoral Commission that why didn't you postpone, the same word used by Mr. Ahmed Kalule, who is supposed to be here, that why didn't you postpone counting, why didn't you postpone voting? However, the Electoral Commission, in its response, had said these people had even destroyed materials. They had destroyed BVV materials, so there was nothing to postpone. But then secondly, and perhaps most importantly, there was the petitioner Hajat Nambi had some bit of a duty, and those are some of the key issues we disagree, and I'm answering your question, why are we taking this matter to appeal? Had a duty to show that actually, because it's not true that those 14 polling stations had registered 100% voter turn-up. It's not possible.
Right.
There was not a single station out of the 197 polling stations which registered 100% voter turn-up. Honorable Nambi, in cross-examination, conceded that she had agents on all those stations. Simon, if I'm your polling agent at a station, from morning, I have to tick that at least to know that 100 people have voted so far.
Right.
Such that at the end of the tallying, I can compare with what your commission is saying. To know, an agent of a candidate should know how many people at least have voted. In none of the 14 did Honorable Nambi lead an agent to say, at this station, whereas we didn't tally, but it had registered 50% turn-up, because these people had voted as per my agent. So it's how ironical is it that whereas the violence affected the Electoral Commission officials, that also affected all the notes of the agents of Honorable Nambi.
To what extent do you agree that there was non-compliance to the provisions of the Parliamentary Elections Act?
Well, there was because I've already told you that there were irregularities in the election. There was non-compliance. The test is how substantial did that non-compliance affect the final outcome. And that's why I'm saying that we should not be quoting 16,000 voters, because those are the registered voters. We had a duty to show, as the petitioner had a duty to show, that out of the 16,000, because voting had concluded, it would be different if the voting had been stopped earlier. To say that maybe voting wasn't concluded and there were no, and the 16,000 could have potentially come.
I find it awkward that now you're raising the question of substantiality.
Of course, it's a matter of the law. It's in the law.
In essence, the law says once there is contravention to the Parliamentary Elections Act.
No. The law says the non-compliance should affect the result in a substantial manner. It's a matter of
the argument is that 16,640 voters were disenfranchised. This is quite a number, isn't it?
And we are saying, and we told court, and we thought that court would have come out with a better explanation of how to distinguish our authorities. Told court that there was no evidence adduced that 16,000 people had voted. That would have been, because voting had been concluded. In election petitions, it's also settled that a petitioner has a burden of proving, which burden is slightly higher than in ordinary civil cases.
Counsel, I don't belong to any top flight law firm or anything. I'm just ordinary. Once the law is offended, substantiality comes
No,
secondary.
substantiality is a matter of the law, Simon. It's a matter of the law in the Parliamentary Elections Act. And it was an issue framed, if you read the judgment. One of the issues was...
Yeah, but there have been precedents. I'll give you the precedent of Chadondo East, Honorable Sitenda.
And Apollo Kantinti.
And Apollo Kantinti.
Yes.
The substantiality test was never raised.
It was, only that it was, and we also put authorities in court to try to distinguish that authority. And our argument here, precedent notwithstanding, our argument here was, if you are saying 14 polling stations didn't vote, this voting was concluded. You had a duty to show that actually these polling stations had registered over this number of voters. Because you had agents there who were recording people who had voted. It's not enough, and that was our argument, and we still pursue it, that for you to say where voting had been, because here there was no tallying, but there was voting. So there was you had a higher duty to prove that actually some people had voted. And according to my agents, my records, they show that so and so, and at this particular point, at least 2, there was this kind of turn-up. Now, and we brought a lot of, anything short of that is actually speculative. Because what is happening is that court speculated that maybe. So what the petitioner threw to court was to speculate, and we are saying that there was never a single polling station which registered 100% turn-up.
Did you have any projection of where this case would end from the onset?
Yes, of course, when you go to court, especially in these times, this is a political matter. It's both legal and political, without doubt. especially where in times where even the judiciary is facing all sorts of threats. We have all sorts of theories. You go to court with all sorts of projections, and just like a football match, you go to court expecting a win, a loss. In courts, there are no draws. So we had all sorts of theories, and we were prepared.
Yeah, but along the way, when, for instance, when your application to cross-examine the witnesses of Nambi failed, did it indicate to you, did it dawn on you that you were bound to lose this case?
No, not, not bound to lose, but we were uncanny with some of the motions. But of course, like I said, as officers of court, we respect decisions, and because first of all, the first fault we had was being refused to cross-examine, because court chose for us who should be cross-examined. The essence of cross-examine, like we appealed to court, was to test the veracity of those averments that the person has made. So what happened that court chose for us, he said, out of Nambi brought 33 witnesses to court, and said, out of the 33, I'm giving you only 10. I'm giving you only 10. When court ordered us to make final submissions, we asked for 1 week. 1 week which would enable us to peruse the record, because a record means we've been hearing, we've been recording. Court has been recording on its gadgets. Can we have that transcribed for us to prepare submissions? And court guided that. No. You don't need the record. You can rely on your notes, on your written notes. And of course, we were given maybe 2-3 days to come up with the final submissions. Of course, and what we are trying to tell court, that we are still within the timelines. Of course, the court is given 30 days to hear and determine. We are still within the 30 days. So the supersonic speed with which it handled, of course, whereas we believe in fair and fast justice and trial, but also there's that saying that justice should not be rushed.
Would you rather it dragged on?
Not drag, work within the law. Work within the, because as it is now, court had at least, even up to date when judgment is delivered, we are within the terms by about 12 more days.
Okay. There is a precedent of handling the case in haste. Do you imagine that the appeal will also be handled in haste? Or you're simply buying time? You put in this appeal to buy time, conversant of the fact that it is impossible, literally impossible, to hold an election within 6 months as we head to elections.
We didn't put it in to buy time. First of all, if we went to a by-election today, if a by-election was to be held today, I'm sure Hajat Nambi would be beaten hands down.
Go for it.
No, what I'm saying, if there's a bad court judgment, especially if you disagree with it, like I've told you, we have both factual and legal issues. We have to disagree with it. The reason why you quote Apollo Kantiti is because there's a precedent. That precedent, some of these bad precedents can come back to haunt other people. So it's also good for jurisprudence. And elections jurisprudence is one of those which has had a lot of varied opinions on different matters, on issues of burden of proof, issues of substantiality, issues of, in the case of JPAM in 2016, one of the issues was exactly that Electoral Commission declared with over 300 polling stations not brought within the threshold, and Supreme Court held differently. So it's important, at least for our democracy, that some of these things are rectified. So that's why we say that the trial judge failed in his duty of analyzing evidence vis-a-vis the law. That's why we think that the Court of Appeal should have a chance of reviewing that decision.
Traditionally, no believes in the court of public opinion over the mainstream courts. What gives you the hope that the Court of Appeal will entertain or will treat your case differently? Traditionally,
no believes are also in the rule of law. So we believe in the court of public opinion, but also believe in the rule of law. And we've used courts so many times. This is not to imagine that that courts don't have issues. Courts have problems, yes. And I don't even blame them, because democratic institutions, when democracy is shrinking, like it is in Uganda, civic space is shrinking, media freedoms are shrinking, academic freedoms are shrinking. You don't expect courts. Of course, we expect them to behave at a higher standard, but we understand the context. Sometimes. You remember when Mr. Museveni released the statement after this Kwempe North election, the statement quoted 50, possibly that is the brief he had been given, that how can 50 polling stations not be tallied, which was inaccurate. As it happened, it was only 14, which represented 7.1% of the overall turnout. So we believe in using these institutions, and we've used them traditionally. We've gone to court several times. Actually,
now, I thought this would give you an opportunity to return to the court of public opinion, let an election run, and then you win squarely, decisively.
I'm sure it would be much more decisive than it were. However, we also believe in what the law says. We are saying we have a problem with this judgment. And many people would not forgive us, saying, how can you let this thing stand? Simon, legal cases are many times decided on precedents. And sometimes when you get a bad precedent, you can only hope that there's a higher court which overturns that, at least for purposes of our weak electoral jurisprudence.
Do you contend that as lawyers for Nalukoola, you ticked all the boxes, or you feel there is something that you never did right?
We feel that we ticked all the boxes. We feel that we did all the boxes. Actually, at some point, we even told the court that the petitioner wanted to shift the burden to Honorable Nalukoola to explain, which is presumptuous. The burden doesn't shift. You have a duty to prove each and every point that if you drag me to court, you have a duty to prove each and every point that you've taken, even if I keep quiet. Even if I keep quiet. So we believe that we ticked all the boxes. But most importantly, we also believe that the petitioner didn't discharge their burden appropriately. And that's one of the reasons why we fault court. We feel that, no.
To a great extent, the buck stops with the Electoral Commission. The Electoral Commission was faulted for failing to run the election according to the law, right?
They said the non-compliance.
Non-compliance to the law.
That was one of the grounds where court annulled the election.
So that in a way suggests that the court is guided by the law to cite failures.
If I'm to expound it at a bigger level, and this is not only about Kawempe North, we have a problem, Simon, and maybe we need a national discussion, given that we're going regional election. Like I told you, we had a meeting with the Electoral Commission after the Kawempe North with my Secretary General and Honorable Nalukoola. And actually, you feel that in the course of the election, at some point, the Electoral Commission's hands are tied, because the Electoral Commission is not in charge of security deployment. Of course, I don't want to be an advocate for the Commission's weaknesses and inefficiencies sometimes. However, what happened in Kawempe North many times was by actors who are even outside the official security arrangements. We saw the explanations from the IGP and from the Minister of Internal Affairs in Parliament. How does, for instance, how do you control the shadowy group who are beating up and arresting people driving unregistered cars? How do you control that? And how do you fault EC? How would EC, which has not even asked for these people, EC has asked police has deployed former people in police uniform, and then there's a shadowy group which can't be controlled by police. And then the new law we hit is that you have goons come and steal a few ballot boxes to disrupt the election in the presence of the uniformed police. How does EC deal with that?
Well, lawyers for Nambi, the petitioner, came out yesterday celebrating and describing it as a landmark court decision. Do you concur?
No, of course, whereas I respect their freedom of expression, I don't find anything landmark about their decision. I don't agree with them. And one of the reasons why we think that this decision should be subjected to fresh scrutiny by a panel of judges is going to an election. How is court going to condone the behavior of people who come to, especially a losing candidate, to sponsor goons, to say that out of the 200 polling stations, you just need to steal 10 ballots and then the election is done? I have the petition in the book. What message are you sending? Especially that court didn't attribute that violence to anyone, because you can't attribute it to a Electoral Commission. How, when the country is going into an election, are you going to to fight this practice, where it might grow. The practice might grow, where you have a person says, even if I'm winning, if I'm losing, I just need to disrupt the election by stealing only 10 ballot boxes, and then the election should be done, or even one.
Well, this adds to a number of election petitions that the opposition has lost in the courts of law.
In the recent past, no, not many.
Kayunga, there was the Kayunga case.
You own different grounds altogether. Nakwede and Nantaba?
Yes.
Or Nakwede and Mwonge?
Nakwede
there was Mwonge versus 5, okay.
Yes.
It was lost on a totally different ground.
Does it serve you any lesson about election petitions?
No, like I've said, even if you look, I remember sometime about 2-3 years ago, Dr. Businje Kabumba and I think another scholar tried to do a study where they analyzed a number of petitions, both at High Court and Court of Appeal. And if you read that book, that compilation, you can find that our election law jurisprudence is varying with all sorts of, sometimes even inconsistent decisions. Very inconsistent decisions. Even this matter of where they denied us to cross-examine some people. We had sought leave to appeal, and then there are inconsistent decisions. One says, no, you can't appeal interlocutory matters. Then there are others where leave was granted, and so on and so forth. And of course, that is all part of a fledgling and growing democracy. What we would ask from court is some bit of consistency, mindful that courts also have a duty to interpret the law in accordance with the whole constitution. Secondly, of course, it's also not so accurate that the opposition has, there are also a number of petitions, and I'm talking post-2021 only, which were thrown out in favor of the opposition candidates. You can think of Honorable Joel Senyonyi, Honorable Dennis Sekabida, Honorable Joyce Bagala, so many were all thrown out by court for being. So the issue is that is all part of the law, losing and appealing, and we have court decisions where they have said that the MP should go out, and then the Court of Appeal overturns those decisions. Some are affirmed. All that is part of the law. The issue that we call for is consistency in the decisions.
Do you want to portray the judge as bad?
No,
or the interpretation of the court was bad?
No, this has nothing to do with the character of the judge or the personality. It has everything to do with the decision. Because court decisions are criticized every day. When a decision is made, it's a public record, it's scrutinized, it can be disagreed with. That's why the appellate courts. So that's why the appellate courts. Sometimes the appellate court can agree with you, another time it can disagree with you. So it has nothing to do with the personality of the judge. It has everything to do with the decision that was rendered, which we can criticize now because it's a public record. We disagree with it. We respect it because from court. However, we were challenging it. We think it's erroneous, both in fact and in law, and we think it should be subjected to a fresh and better scrutiny by a panel of judges.
Well, let's return after the break, and the question remains, what are the implications and what is the way forward after yesterday's annulment of Nalukoola's victory? Good morning.